let's go to a recap of what we have learned. We learned that there exist different considerations for the protection of IP. One of them is territoriality. There is a misconception that once you get IP protection in one country, it is valid globally. Well, we now know that this is not true. Territoriality is one of the basic principles of international IP law. It means that IP rights are only valid in the country where they were granted. We also learned that internationally, the Berne Convention, the Paris Convention, and the TRIPS Agreement recognize the principle of territoriality. This allows countries to form tailor-made domestic laws governing intellectual property. The above three international treaties also lay down the principle of national treatment for IP protection. It says that the member countries should provide the same advantages, rights and treatment for protection of intellectual property to citizens of other member countries as their own citizens. Next, we learned about the national character of intellectual property rights, which means the legislation of a country governs that intellectual property rights in that country. So, when applying for patent registration in India, the Indian patent law will apply to you and not the law of any other country, even if you are a citizen of another country. When seeking IP protection in other countries, you need to decide on the countries in which you want to file for protection. There are some crucial factors to be considered to make this decision, like countries where you propose to target selling your product or the country where you want to manufacture and the strength of IP protection laws in that country. The number of countries you wish to file for IP protection will also affect your decision to either file directly in the country or by filing a PCT application. Both alternatives have cost and other implications. Your interest and ability to monitor international markets for infringement of your rights and to take action against the infringement will also be a factor influencing your decision. We also learned that other than national filing, there are different international filing procedures for different IP rights. For example, PCT and Paris Convention guide filing for patents and Madrid Protocol is followed for filing for trademarks. While there is no global registration system for copyrights, like in the case of patents or trademarks, but the Berne Convention provides for no formalities protection, and as soon as your work comes into existence, it will get automatic protection in all the member countries of the convention. For industrial designs, we have the option of filing the reciprocity application in India. That's all. Let's move on to the next lesson.
Namaskar and good afternoon. Good afternoon to all. I'm thrilled to welcome you today at the L2 Pro workshop on demystifying PCT filing, the cost-effective strategies for startups and MSMEs. I'm your host, Nitin Sharma, and it's my pleasure to invite you today. I work at Qualcomm overseeing various IP initiatives for Qualcomm India. We have initiated this webinar series to engage with you on fascinating world of intellectual property. Indeed, we are in the midst of the century of intellectual property, and for any country that aspires to take a leadership role in the global arena, intellectual property will play a very important role to achieve that goal. Through this webinar series and the L2 Pro platform, our goal is to spread awareness about intellectual property rights, the IP strategy, and how to effectively use an IP strategy for startups, for MSMEs, for basically any organization that deals with innovation and technology. Today's webinar promises to be particularly engaging as we dive into the discussions around building cost-effective strategies for PCT, filing like PCT applications for startups and MSMEs, which will be presented by our distinguished speakers, which we'll introduce shortly. Now, PCT is very important mechanism for anyone to enter the global market, and therefore, and there are lots of strategies that one can use to to further the business goals of the particular organization. So we'll discuss that, but let me take a moment and introduce you to the L2 Pro platform, which is available free of cost to anyone who wants to learn not only basics, but intermediate and advanced concepts around intellectual property and IP strategy. So this, the idea of L2 Pro came from our experience with the startups as part of our Qualcomm Design India Challenge program. We realized that there are a few startups who are pretty good in protecting their intellectual property and making a good use of it to further the business goals. Whereas there are other startups who really needed handholding and guidance in terms of how to build an effective IP strategy, what are the key innovations, how to protect them, and so on and so forth. This also aligns with the government of India's policy of Startup India and Make in India. And this particular platform was created in collaboration with DPIIT and CPAM and NLU Delhi. Now, this program can be accessed through two mechanisms. One is the L2 Pro India website. So you can access it through l2proindia.com. L2 Pro stands for Learn to Protect, Secure, and Maximize Your Innovation. It's an e-learning program. Primary goal is to educate startups, MSMEs, or academic institutes which are doing R&D. Basically, any innovator who wants to learn about the fundamentals of intellectual property. Through this course, we aim to create a better understanding on protecting the innovations with patents using copyrights, developing trademarks, and primarily integrate IP considerations into the business models, which is something which is really missing in many of the conversations, right? Now, there are three levels in this course. One is the basic level, which covers the fundamentals of patents, trademarks, geographical indications, etc. Intermediate level will cover details around NDAs, restrictive covenants in the agreements, basically filing and securing the IP, a bit about commercialization, how do you assign the rights and license, what are the kinds of licensing arrangements that can be made, and so on and so forth. The advanced level deals with using IP as a tool to access funding. There's also an introductory session on standards and standard setting organizations. There is also a discussion on disputes. How do you deal with disputes, infringement, analysis, validity of patents, and so on and so forth. So basically, it's a pretty comprehensive course that can give you a very good idea about building a good IP strategy and how to make use of it. Now, the second way to access this course is through mobile app, which is available on Play Store or an App Store. There are some screenshots which I'm showing here, highlighting the look and feel of the app. It covers the concepts. This starts with the introductory video, then covers the concepts on that topic. And it also has some questions as it goes along to check your intermediate understanding. And lastly, once you complete a particular module, you get a certificate which is co-signed by NLU Delhi, CPAM, Qualcomm. So it's a pretty good, it comes with its own QR code and basically, a bit useful certificate to have. All right, so with that, let me introduce you to our speakers. The first distinguished speaker today is Sri Jaiveer ji. Jaiveer ji is an assistant controller at the IPO office under DPIIT. Since April 2016, he is acting as a controller under Patents Act, deciding patent applications in India. He also serves as an authorized officer for PCT search and examination under WIPO, and works in the IP Office International Affairs Division. His responsibilities extend to IP policy, parliamentary, and related government matters. Previously, he was an assistant professor at NIT Jalandhar and BPS Women University, with an earlier stint as a shift engineer in the textile industry. He holds BTech and MTech in textile engineering and has advanced training in IP management from CBS, WIPO, and Harvard Law School. He's also represented India in multiple WIPO delegations and has published research in peer-reviewed journals and conferences. So, Mr. Jayviji, it's an honor and privilege to host you today. Over to you.
Sir, good afternoon, everyone. The topic is about demystifying PCT filing, a cost-effective strategy for startup and MSME. I think it's for all, it's a cost-effective. If it's strategically used and how we are using it, it's a multiple benefit other than cost-effective. I'm trying to highlight these points. Only time is 20 minutes. I try to wrap up as fast as possible. Now, generally, we all know, I'm not going to basics about IPR patents because everyone I'm expecting more or less everyone know about this field. So what are type of applications generally we deal with? First is the ordinary application. What is the ordinary application? The application directly filed in context of Indian Patent Office. Directly you are filing the patent office in Indian Patent Office. Means you are not claiming any priority. Priority means you have not claiming any prior application, you are directly filing that application. It's the ordinary application. Second is a conventional application. The application filed under convention route or Paris Convention route. It's the convention application. It should be filed within 12 months period from the date of priority. For example, if someone has filed a patent application in Japan, or they want to file that application in India, so they can claim priority of earliest file of application in Japan or any other country, and that is a 12 months period. After 12-month period, you will not be allowed to file under this route. And third route is the most widely used route, that is the PCT route, Patent Cooperation Treaty route. Under this, you can file the application within 31 months. In some countries, like we can say US, China, it's 30 months. In India, it's 31 months. So one benefit of PCT is reflecting in timelines. You have 31 months period. Multiple countries, you can go, you can make decisions, and you have much time to prepare your mind or make decisions regarding where to file, where not to file. So it is the type of applications we deal with. Now, before going into PCT details, uh, uh, I'm trying to tell about patent process. So what is the patent process? Patent process is generally many steps. You just file the application in patent office. If you make a request for examination, one important thing you should keep in mind for patents, because it's quite different from other type of IP, you need to make a separate request for examination. Filing is itself not considered as a examination. You have to file a request for examination to trigger your examination. That should be filed within 31 months from the date of filing or date of priority, whichever is earlier. Now, after filing the application is published within 18 months from the date of prior to date of application. But you can request for early publication by filing a suitable form or fees. So your application then will be published within 1 month. Generally, it is published within a week. After both requirements met, your application, you have filed request for examination and your application has published. The application is proceed for examination. After examination, the application FAR, first examination report, is issued, and you have to reply within 6 months, or you can extend this period from 3 months, and new amendment of 2024, you can extend further 6 months also. After that, FER reply based on everything is okay, the application is granted. If still there are some objections, you are offered a hearing, and accordingly, after hearing, you can make submissions, and your application is either rejected or it's granted. This general process we have. Now, why this PCT things came into law? First thing, because a patent is a jurisdictional right. You have to go each country by country. For example, you want to apply in Japan, you have to go Japan. You want to apply in another country, you have to go there as well. So this is the general idea. Now, PCT application is gives you 31 months. You can file application in India, then within 1 year you can file a PCT application, or within 31 months from the date of priority you can file another application in any country. You can in 30 months, in some countries it 30 months, in most of the countries 30 months, in India it's 31 months. Now PCT is actually is a gateway for global protection. How? Because you can file a single international application, and on the basis of that you can make entry in multiple countries. But there is a widespread, there may be confusion. PCT is something global patent. There is no such concept global patent. It's only global patent application you can make, not a global protection. Protection is jurisdiction always. Please keep this in mind, because you can file a single application, you can go in 30 or 31 months in multiple countries, but patent grant is under the control of respective IP or patent offices only. After that, what is the overview of PCT system? Like I shared slides show these things to you. Is it visible?
Yes, sir, it is visible.
Okay. Now this is the just overview of our I think this is better visible now. Overview of PCT system. You have an invention. You can make international application. You have two options now here. Once you have invention, you either file a application in a country or in a you can say your nation in your country, and then within 12 months you can file international application, or you can directly file international application. So in this way, you can file an international application, and then within 31 months you can file a patent application in any number of countries that are the part of PCT. Almost all countries are part of PCT. After that, and you file an application. As a resume application is filed, the international application PCT application within 12 months you file. In 16 months, then we transfer ISR within 13 months. ISR, the international success report or international opinions are generated and they are served to the WIPO. And in 18 months, it is published along with the first publication. After that, you can also make some like options you have, like these are optional things, like you can make a supplementary request for examination, or you can request for international preliminary examination, that you idea whether your patent is and having novelty inventive step or not, or some have basic defects or defect free or not. So according to this, you can make your prepare mind whether your invention is grantable or not, it would be granted or not, or in which countries it can be granted. So you can prepare your mind basis of these reports. Or second important benefit you have, you can amend your application under Article 19, even under after ISR, you can under Article 34. So amendment, you can make amendment before entering into national phase. After entering into national phase, then you have to pay some fees like amendment fees. Form 13 you have to file in India. So it means it's saving your cost for amendment. You are making amendments before entering into national phase. So it's one of another benefit that PCT involves, and it's cost how it you can use for cost reducing your cost. After that, you can in 31 months you can enter into a national phase. Now, some important point regarding PCT and other patent applications also. First, file then publish. Always make sure that you first file your application as a you can file international application or a basic application, but you file that application, because by filing you will save your priority. Otherwise, if you are published somewhere else in journal or in some articles, that document will become the novelty, will become the priority. Your own publication prior to filing patent application may compromise novelty, inventive stock, or invention. So always try to file. First publication should be in the form of patent application. Now, second point about important point I'm telling you about foreign filing permission. PCT national phase applications, even if you are filing in India, if you are filing in India as a issuing office, or you are choosing India as an international search authority or international preliminary examination authority, that application is treated as foreign application. So if you are trying to make directly a ISA application, in that case, or you are making that application without filing a patent application in India prior to at least 6 weeks prior to that. Okay, you are saying I should speak a louder bit, yeah? Hello. Am I audible now? Is it clear?
Yes, sir, you're audible. The
Okay, okay.
participant says that pretty loud, sir.
Okay, okay, okay. What you can do in second case, for example, foreign filing permission. What you take if you are filing a international application even before the India as an ISA or IPEA, that application is treated as foreign application. Under Patents Act, there is a section 39. That section says that whenever you are filing a application outside India, you have to take either a permission or you file a for the same invention a patent application in India at least 6 weeks before that international application. So always take permission. Otherwise, this patent application you have filed, you may not, the patent will not be granted. And if granted, that patent is shall be revoked. Or this also stringent rule that is also have a jail term as well. So always make sure that at least you file a patent application in India at least 6 weeks before, or you take a permission. Permission you can take, its average time is 12 days only. You can take permission for this. These two things you should keep: first file and then publish, and second concept foreign filing permission. Up now foreign filing permission comes into role to always make this also if you make a national phase application on the basis of international application. Then second important thing that there is a requirement of section 8 in Patent Act. You make you give particulars and details of foreign filing. So always give particulars, details of these application as well. Otherwise, Form 3 is also a ground for pre-grant opposition, and its application may also be face difficulties. So these things you should do it take into account. Now some benefits we are giving for ISA applicants. First important thing that what we are giving for ISA applicants is expedite examination. What you can do, because if you are you have chosen India and ISA, in that case you are eligible applicant for a expedite examination. You can make request for expedite examination in form that is the form 18A, and then your application will be fast tracked and a different queue, a special queue will be awarded to you. So that is one of the benefit government has extended to the applicants who are availing the benefit of ISA. Okay. And second, irrespective of whether you are ISA or not, we have given 80% fee concessions to some businesses, because I am told that the attendees or participants are MSME, startup, or educational institutes. So this benefit covers all three candidates. You are eligible for 80% fee reduction. That is a huge reduction. You can avail it. And if a big corporation, a big company has to pay 28,000 for filing an examination, and you just need it to only 5,600 rupees. Now, one scheme, this is the fees about the fees is payable to government. That is the, you can say, application fees, examination fees. There is also one most important component, that is the fees payable to sometime patent attorneys, you can say, or you can say facilitators. For this also, we have a scheme that is called Startup Intellectual Property Scheme, SIPP scheme in short. You can directly put it in Google. And that scheme was earlier for only startups. But after that, it has been extended to any individual or an education institute as well, provided that they avail this benefit through TISC. TISC are the Technology Innovation Support Centers. They are WIPO supported centers established in India. You can just go on WIPO website, you just Google, just write on Google TISCs in India, you will get a list of TISCs. You can approach that TISC will help in availing this benefit. Now, how this scheme works, I will try to tell you. If you are a startup, you select a facilitator. We have a list of facilitators on our website. There are more than 500 facilitators in trademarks, around 500 patents, and around 2,000 in trademarks. You can avail benefit of this. You can select any of them, and their contact details are available there. They cannot charge anything from you. This is, I found them, there are many schemes run by government, central government and state government. But most of the schemes are reimbursable scheme. You first make a expenses and then they will reimburse it. But this scheme is entirely different. Here, the facilitator cannot charge anything from you. What is payable to them, the government or office of CDPT will pay to them. They cannot charge anything from you for facilitation point of view. Now, facilitator will do everything, that most of the thing like drafting, filing on your behalf. If you are a startup, and you just need to select a facilitator. And professional fees that is fixed is paid by government to the facilitator directly. No involvement of you. Now, in 2019, that was extended to innovation creator as well. Or in 2023, it has been extended to education institutes. Here you can select a TISC, Technology Innovation Support Center. Again, I'm saying you can just Google it and you can find it details. And the facilitator will help you to select facilitator. And facilitator is, you can do all things like filing, drafting on your behalf. Registered patent agents are more than right. Patent agents or facilitator are worth 2,500 and patent agents are around 500 only. The fees is payable to facilitator in two stages. First stage is filing stage. We pay 15,000 if they have filed application. Second is disposal. Whether it's grant or refusal, that is paid 25,000 to them. If there's an opposition, then in patent is about 35,000. The scheme also covers patent and design and trademarks, so they also have fees reimbursement. Okay, this international application, you can file this scheme has been extended in 2023 to the applications that are IS applications as well. In IS application, there is no disposal stage, so you are eligible for the applications that are the applications that are ISA IP application having IS and chosen India as an ISA IP. The filing 15,000 rupees are also paid here. If someone is availing this benefit, first they can file ISA application, then they can take benefit of this scheme, and then again national phase entering national phase application, they can take benefit of that also. Patent facilitators, you can just put in Google patent SIPP scheme. You file a list, or website link, and you can click here. It's visible on screen that you patent agent number and details, contact number. You can contact them. You can select them. They will do on this behalf. This all about that we are covering. Now, one more benefit, there are many benefits by ISA. I'm trying to give some benefits in brief, what you can know. First benefit is the filing time. In PCT application, you have 30 or 31 months period. Okay. Second is the patent term. You can also have provision. You can extend your, for example, you file a patent application in India. You directly filing a ordinary application. So your term of patent will start from the filing of ordinary application, date of ordinary application. But if you filed that ordinary application and then you enter India through PCT national phase application, or in that case, you can extend your term up to 12 months because patent term starts from date of filing of international application, not the first application. So second, you can leverage it. If you really want, so you can leverage it, like for example, extending your patent term for 1 year as well. Third important, patent fees. In patent fees, SIPP scheme we are giving, you can take eligible, facilitator fees reimbursable. And second, in India, patent fees is not higher for ISA-IP applicants. You can avail that benefit. In foreign countries as well, like China, USA, there's huge discount is given for ISA applicants. Okay. Third important, expert examination. You can avail the benefit of expert examination where your application is fast track. You can avail benefit of this scheme. And fourth important benefit is the hand holding. Whenever you are filing an ISA application, you will receive an ISR, International Search Report. Or if you are availed, you have made request for you make request for IPE, International Preliminary Examination, then you will receive preliminary examination report as well. It will give you a hand-holding time. You have a report in front of you before making decisions, like important decisions, whether you want to enter in other countries or not, whether you want to go there or not. For example, an ISI said that invention is already available in public. That is not novelty or inventive time. In that case, you can think of your invention again, you do more research on it, or you will not go in other countries, obviously. So that is also is saving your cost as well in this case. And one more important is amendment. What happens, I already discussed also, what happened, because sometimes you make amendment. So amendment in every country, you make amendment. Most of the countries, you have to make a formal request for that. That is includes some fees. So if you are making some amendment before entering into that country, so you can make amendments, 2 times amendment under rule 19 and also 34 article of the PCT. So these are some benefits that PCT involved. So you can use this. This obviously will be cost effective and also time effective. So you can use this scheme, and that's all about the patent we cover. And my time, I think, almost is over. Thank you so much.
Thank you, Jaiveer, for a very informative piece of information. I guess very important to know the details of facilitators and also the other benefits that are available to MSMEs and startups, especially with respect to PCT filing, because that's something that seems to be challenging, and people seems to have a bit of concern about going international. So these facilitators can help us cross that barrier. So our second distinguished speaker is Sri Sandesh Shastriji. He's a partner at KNS with a practice focused on mechanical engineering, patent and design prosecution, and that includes valuation as well. He has worked in patent domain since 2015, handling drafting, filing, prosecution, and contentious matters across diverse technologies. That includes mechanical systems, robotics, etc. He also advises on industrial design protection and enforcement. He routinely provides opinions on patentability, freedom to operate, due diligence, and infringement. Leveraging his techno-legal and business expertise, he offers strategic counsel in areas spanning electronics, energy, biomedical devices, etc. He regularly appears before Indian Patent Office for prosecution and opposition matters. He worked with technology consulting firms specialized in cloud, AI, and analytics before joining KNS Partners. Sandeshji, it's an honor to have you today. Over to you for your insights into this great topic.
Thank you, Nitin. Thank you for the introduction. Before me, distinguished speaker Jaiveer, thank you for the very informative session. I'll further add to whatever Jaiveer said about PCT filing. Although he added several other things, mine is focused mostly on the PCT filing. I'll share my screen. Please let me know once it is visible. Yeah, is my screen visible?
Yes, it is visible.
Okay.
Go ahead.
Okay, I've put it on the screen, slideshow mode. Hope it's visible. Okay, so today topic that we have is demystifying PCT filing. So basically, what is PCT? So PCT is an international treaty wherein there are about 155 or 157 countries which are members of PCT. And what this allows is PCT application basically allows single international patent application, wherein it allows or gives you an opportunity to file the same international patent application in several large number of countries which are members of PCT. Okay, so with a single international patent application, we can file it in number of countries. That's the facilitation that PCT application gives. As Sir also mentioned, Jaiveer mentioned, the PCT is not a granting authority. Rather, it's a patent application through which you can file it in several countries, which is called as national phase applications. This is the brief overview about PCT. Okay. So some of the characteristics and advantages of PCT filing is, firstly, it's an international treaty that was administered by WIPO. WIPO is World Intellectual Property Organization. So this is for facilitating filing patent applications globally. Okay, and as I said earlier, with one international patent applications, you can file it in several countries. That's the facility that PCT gives, and it covers approximately 157 countries. I mean, it's like almost the entire Earth basically. It covers all the countries. Very few countries that are not covered in PCT filing, but mostly all the important countries wherever you might have a commercial benefit or a market opportunity is covered by PCT filing. And the biggest advantage of PCT filing is, apart from having the global market, it also provides international search report as well as written opinion on patentability. I'll explain more about it later, but just know that it gives a search report plus written opinion once the PCT is filed. Okay, so it also allows you to delay the filings in different countries. Generally, in countries like USA, the timeline is 30 months from the priority date, and in countries like Europe and India as well, it is 31 months from the priority date. Okay, as I said earlier, it does not grant a patent. PCT application is not for granting of a patent, but the national or regional offices decide about granting. It's just a facility to file the patent applications globally. Okay, so because you can defer the national filings, you have the opportunity to assess the potential cost or commercial opportunity of the patent application, and then you can take an informed opinion while filing the national phase applications in different countries. Okay, this is the some of the advantages and characteristics of PCT filings. Okay, so I think Sir briefly touched upon this, but I will, try to keep it a little more detailed regarding the timeline. So there are basically two options if you want to file it in globally. Okay. Now, generally, when we say local application, it is for Indian applicants, it will be mostly India. You first file it in India. That if we consider as 0 months, then under Paris Convention route, after 12 months, you need to file it in different countries. Now, let's say you have, for your product or for your invention that you have filed a patent application for, you have market in several countries. Let's say about 10 countries: USA, Japan, Europe, China, Australia, and so on. Under Paris Convention route, you will have to file different patent applications separately in all of these after 12 months, immediately after 12 months. So beyond this, Paris Convention does not allow you to file it in different countries globally. Okay, this is under Paris Convention route. Whereas the PCT timeline is quite different. That's why, the maximum foreign patent applications that we get in India also is through PCT national phase. Very few opt for Paris Convention. Now, let's say you have only one country apart from India that you want to file, then Paris Convention route might be better. But if you want to, file it in several different countries, then PCT is the preferred route. So what happens is, once you file the priority application or local application, you will have 12 months time to file the PCT application. Then, as I was mentioning earlier, the biggest advantage with PCT is that you get the search report plus written opinion. So this search report basically informs you about your invention's novelty, inventive step, and industrial applicability. So these are the major things which requires, major test for patentability. Once these three things are clear, almost all the others are minor compared to this. Therefore, it will give you an opinion about the novelty, inventive step. With this ISR and written opinion, it is got in the 16th month itself. Okay. After that, the publication will happen. Okay. Now, let's say this international search report has a negative opinion. Negative opinion in the sense, it is not, your invention is not being given with the inventive step and the novelty. Then you have an option to request. You have an option to file a demand. Okay, wherein you can file the response to the search report and written opinion, and then you can say, for these, you will present arguments and say that for these reasons my invention is still novel and inventive step, and includes inventive step despite several documents being cited in the search report. So this option is there, and within the 22nd month from the priority date, this has to be done. You will have to file a demand along with the reply. Then what the searching authority will do is, they will further assess your reply and give the final patentability opinion in the form of IPRP. It is called as International Preliminary Report on Patentability. That is obtained in the month of 28 from the priority date. Okay. Then within the 30th month, you will have a proper opinion about whether your invention is novel or not, or whether it is inventive or not, and then you can take an informed decision to file it in different countries. So after 30th month, you will have to file it in, if at all you want to file it in USA, the deadline is 30th month, and countries like India and Europe offer 31 months deadline. Okay, so this is the broad timeline for PCT and Paris. So as I said, if at all you want to, one of the tips that I can give to MSMEs and startups is that if at all you feel that there is only one country that apart from India I want to file, then Paris Convention route might be better. Otherwise, PCT is preferred option because it gives you, first of all, a lot of timeline. It gives you an opinion about the patentability, and additionally, if you want to file it in more countries, this is a better route. Okay, this is the timeline and the comparison with respect to Paris Convention. Okay, moving ahead. So, I mean, why is it important that startups and MSMEs should care about PCT, right? So, first of all, through this PCT filing, you get the access to global markets, right? This is one of the ways where you can file the patent application in different countries, right? So, early PCT filing keeps international expansion options open. So if you file the PCT later, because you will have sufficient time, you can decide whether you want to file it in different countries. So you will have the options to file it in 157 countries apart from India. That's the advantage with the PCT filing. Then what it also does is that, because fundraising is a very important part for startups and MSMEs, and valuation also. PCT application is an indication that you're looking for a global market and you have a global intent. Therefore, it sends out a very strong signal to the investors, partners, and licensees, and therefore PCT application is a good signal indicator in that way. Okay, then. As I showed earlier, because you have 30 months or 31 months timeline from the date of filing the priority application to file it in different countries, you can defer heavy investments, right? So the filing expenses can be quite expensive in some of the foreign countries, USA, Europe, Australia, etc. So you can defer basically you're getting 30 months time to arrange the money you want to file it, arrange the money that you may have to spend for filing in different countries, right? So this is one advantage of deferring the heavy investments. And once you get the IPRP and ISR written opinion, you have the opinion on patentability of your invention. Therefore, once you have the opinion, you can take an informed decision whether you want to go ahead with filing in different countries. Therefore, you have a data-driven, decision to make based on the ISR written opinion as well as the IPRP. Okay, so additionally, it also supports collaboration and licensing, because global filing is a good indicator, and therefore it supports collaboration and licensing. Okay, these are some of the things why MSMEs and startups should really care about PCT. So although there are 157 contracting states in the PCT under PCT, Indian applicants have the option to choose only 8 or 7 patent offices as searching authority. Searching authority in the sense these patent offices will search and give an opinion on the patentability, right? Of course, Indian Patent Office is one of the option. Apart from Indian Patent Office, we have European Patent Office, Austrian Patent Office, and Australia, Korea, Japan, and US PTO. So these are the options that we can choose as searching authority as an Indian MSME or an Indian startup. Now I have also just put a approximate fees. These are the official charges that is charged by the different patent offices when you choose them as a searching authority. Okay, so India, it is 15,000, and Europe is 55,000, and USA is very, very expensive, in the range of 2,20,000. So as you can see, India is a very cost-effective, option for MSMEs and startups, and India also offers a very good quality of the search report. Of course, also, although Europe and USA are generally known better for the quality, but India is almost up to the level of Europe and USA. Therefore, especially for MSMEs and startups, considering the cost barriers that you might have, choosing India as a searching authority would be a very prudent decision to make, because it's cost effective, and at the same time, once you get the Indian search opinion, the prosecution of the national phase application in India will also become very soon, very quick, or the priority application. See, suppose you have filed a priority application in India and you also choose searching authority as India, you would have already got the patentability opinion through a search report from the Indian Patent Office. Therefore, the same will almost be applicable for the Indian prosecution also. And therefore, grant and the prosecution in India will become generally quicker when you have the when you choose the searching authority as India. I hope that's clear. Okay, so as I said again, I think India might be the most prudent decision for especially for MSMEs and startups. Although some of the big large corporations might choose Europe and USA as searching authority, considering their interests. But especially for MSME and startups, India is a generally good option. Of course, there is an option to choose Japan, Korea also, but these three are the most commonly chosen searching authorities. Okay, so as just going back to the timeline again, once you file the PCT application, right? This is at the 30th month or the 31st month is when you enter the national phase into different countries like USA, Europe, Australia, Japan, China, and so on. So, what are the strategies that you can adopt while entering the national phase is what I'm going to speak about now. Okay. Now, firstly, you will have to prioritize the countries where you want to file the national phase application. Because, see, there are 157 countries. It is not necessary that all of them are your, all the countries have a market potential for your invention or for your product or for the process that you have patented. Right? Therefore, selecting the appropriate jurisdiction is very key. Okay, so now let's say apart from India, you have a big market potential in USA. Then of course USA should be on top of your list. And let's say Japan and let's say Europe. Let's say if for your product you don't have a market in China, then you can choose not to file in China. Rather, you can file it in US, Europe, and Japan, where you have the big market. And one other factor to consider is one of the advantages of patent is that you're blocking the competitor from using this invention, right? Therefore, competitor presence is also very important. It's not only where you have the market potential, but also where the competitor is operating. That is also very important, right? So considering these 2 3 parameters, like the market potential, where you are doing the manufacturing, where you have the competitor presence, and considering the regulatory fit also, you can prioritize or choose the countries where you want to file the national phase application. Okay, and in some of the countries like Japan, Korea, EP, translations are involved, and China also. So therefore, if at all you want to file the national phase applications in these countries, then you have to plan very very early, right? So that you get the translation on time, and basically you can budget time as well as budget the cost also, and this will avoid the last minute delays and therefore additional cost, right? So planning translation early is very important. And as I said earlier, you will have an opinion by the month of 16th or 28th latest. This is the final opinion, right? So before entering the national phase in different countries, you already have the patentability opinion, right? Use that and then decide whether you want to file it in different countries or not. Okay, so this will avoid unnecessarily filing of national phase applications in several countries, which is not required, right? And beforehand itself, it's very important to plan the budget clearly. The filing estimate, the translation fee, the attorney fee, which is quite expensive, all over the world, especially in the Western market like USA and Europe. The attorney fee is very very expensive, including the official fees. So it's very important to plan it properly with a proper budget, along with your commercial milestone. So you will have some, now let's say you have some revenue plan for USA. Then how much can I spend on IP protection? You have to plan all those things, considering translation fee, filing fee, as well as attorney fee. Filing fee is basically the official fees that is charged by the government. So vis-a-vis your commercial planning, you need to plan how much I can spend on my IP protection in these countries. Okay. Okay, moving ahead, I think Sir in detail explained, Javeer Sir explained several benefits that is offered by the Indian government as well as the Indian Patent Office. So some of the schemes that I've highlighted here is that there is one SIP EIT scheme, right? So they give 15 lakhs reimbursement, right? Or 50% of the total expenses. Now, let's say beyond 15, you're spending 30 or 40, whatever it is. 15 lakhs is the maximum, of course. Or else if you're spent around 10 lakhs, then they'll give 50% of total expenses. Okay, something like that. For international patent filing in the field or by the electronics or IT MSMEs only. So this particular scheme is only for the startups and MSMEs who are operating in the field of electronics and IT. Okay, so I think once you Google, you will come to know more about this scheme. Just know that there is something like this. Okay, that is important. Of course, if you want to dig in more about this, you can find it on Google, or you can reach out to appropriate professionals who will provide guidance on this. Okay. Then we have the reimbursement structure. So basically, at the time of filing, 25% will be reimbursed, and after grant, 75% will be reimbursed. So therefore, getting grant is also very, very important. Okay, for reimbursement. And there is one more patent filing reimbursement scheme. Right. So under this, for domestic filing, up to rupees 2.5 lakh is reimbursed, and for international patents, it is 5 lakhs. You can Google and try to know more about these schemes. I think this facilitator support, sir explained in detail that there's a list of facilitators who provide facility, and the cost or the professional cost is borne by the government. And eligibility for startup and MSMEs to avail all these benefits, or the benefit offered by IPO, is that for startup it has to be a DPIIT recognized startup certificate, and for MSMEs it will be Udyam registration certificate. Okay. Okay, I'll just finish. So some of the cost saving strategies is that it's very important to file a very strong priority application to avoid costly fixes later. At the time of filing in India itself, we have to make sure that we take into all the consideration and provide the best patent application or the best quality of patent draft, right? Initially you can keep the claims lean, because in different countries, if you file large number of patents, there will be additional fee for more number of claims. In India, up to 10 claims it is free, and beyond 10 claims it is chargeable. Similarly, in foreign countries also, like Europe allows 15 claims. Beyond that, it has a very high fees, which MSMEs and startups have to consider. Okay, so you although there is you can enter national phase applications much before, but delay it until the last moment, because you can consider the market, you can consider the revenue path. All those things will be clearer during the 30-month period. Therefore, you can delay the national phase, of course, not till the last moment, but you don't need to file it very early also. That's the point. Okay. And yeah, so in addition to, as I was mentioning earlier also, depending on your go-to-market strategy and funding milestones, you have to align the strategy with the country filings, right? So wherever you have market, that is where you have to file. There is no point in filing in a country where there is no market for you, right? So these are some of the cost-saving strategies that you can adopt. That's it from my end. Thank you.
Thank you, Sandeshji. I think this was again very informative, especially the practical strategies. So moving on, our third distinguished speaker is Shri P.V. Kulkarni ji. He is an assistant director with 24 plus years across manufacturing, and MSME developments, advancing innovation, quality, and entrepreneurship. He led outreach for government schemes like vendor development, entrepreneurship, management development programs, catalyzing MSMEs competitiveness. He built partnerships with startups, academia, and industry, mentored entrepreneurs, and promoted lean and QMS adoption. His experience in process engineering, technology adoption, and policy implementation across multi-state assignments. Kulkarni, over to you. We'd really love to hear perspectives from MSME point of view as well.
Thank you, Nitinji, and thanks to all the other members who have presented their part. I will just like to share my presentation.
Okay, I guess while we have the technical difficulty fixed, maybe we can take a set of questions. Okay, looks like I think we're all set.
Good evening, all of you. Thank you. Thank you for your patience. As was explained earlier by Mr. Sandesh ji and Jaivir ji, this PCT is an international patent law treaty that provides unified procedure for filing patent applications to protect inventions in each of its contracting states. It not only includes the startups, but also MSMEs from our country. Now, the topic given to me over here is what are the various challenges faced for PCT. So we can classify these key challenges in 4 different sectors, we can say. One is financial, second one is procedural, third one is informational, and fourth one is resource-based type of challenges faced by MSMEs. If you look at the financial, that is concerned with the high cost of international protection, because the total cost of securing patents via PCT is often prohibitive for small businesses, as they are having very less volume, production of volume and all other, their reach to the market. So they find it very difficult sometimes to go for this particular PCT. And while the PCT itself offers centralized filing system, national fees entering individual countries requires significant fees for each jurisdiction, along with the professional fees for foreign patent attorneys. And there are two parts, that is the translational cost and the maintenance fees, that is scribed. MSMEs must translate their applications into the official languages of the target countries. Say, for example, in Sweden or some other European country they are going, then they have to go with the local translation, whatever their PCT is having. So for that, they have to go with that local languages over there. And each country requires recurring annuity fees to keep the patent in force, creating long-term financial burden for the MSME. The next is the procedural. The complex technical procedures adopted. One is the documentation burdens. The PCT process involves strict timelines and whose IP expertise. Most of the Indian MSMEs are facing this problem, so that can be taken care of. Then third one is about informational. It's limited awareness of support scheme. Government of India and state governments, in certain cases, they are doing good work as far as the patents and other laws are concerned. And the financial assistance are also provided. Even the awareness programs are also organized for just providing information about the IPRs. And there, we find that this particular, whatever awareness we are doing, that is to the limited extent, and it should be more and more, it should be done, and it should reach to the ultimate MSMEs. The next one is the resource-based type of threats, we can say. These are the market and strategic barriers, enforcement challenges. Even with a PCT granted patent, MSMEs often have the financial muscle to litigate against large corporations in foreign countries if their rights are infringed. In certain cases, we might find this particular problem. And the commercialization gap, obtaining a patent via PCT is only the first step. Many Indian MSMEs struggle to find global partners or licenses to commercialize inventions effectively. So these are some certain issues which we came across specifically from the MSME point of view. Now, what are the answers for this? There are certain answers for that from Government of India. We are having different schemes, and through these schemes, we can reach to MSMEs for addressing various issues what they are having. Now, first of all, I will just like to introduce the all available over here about what exactly MSMEs and how we are related with IPs. This is a MSME Development and Facilitation Office. These offices are available in almost all states. At least one minimum office is there in one state. Goa being a small state, we are having one office, but in Karnataka or in Maharashtra, multiple offices are there. And this is the general scenario of the MSME sector. 31.1% of GDP, 35% of manufacturing output, and 45% of export. Second largest employer after agriculture, 28.7 crore employment under Udyam portal as well as UAP. These are the figures from 30th September 2025, and 6.8 crore MSMEs registered on Udyam portal. So this is what in general the MSME scenario we can just look for. And from 1st of April 2025 onward, the definitions of micro, small, and medium enterprise are enhanced, like from investment point of view as well as from turnover point of view. Now, the investment, if it is up to 2.5 crore and turnover up to 10 crore, it will be termed as a micro. And similarly, for small and medium, you can just see 25 and 100 and 125 and 500. That is investments and turnovers. Now, why government has taken these decisions and increased these particular limits? Because very clear-cut instructions or clear-cut directions are there for that we want to promote investment, incentivize MSMEs and scale up, so that we should go towards the Atmanirbhar Bharat in a very earlier stage and enhanced coverage. So these are the main things which are considered as a benefit for MSMEs. Now, the Ministry of MSME, we are that is MSME Innovative. MSME Innovative Scheme has three components in it. One is IPR, intellectual property rights. Second one is incubation, and third one is the design. We'll just go through one by one. Intellectual property rights, if you look at these components of IPR, means for IPR scheme up to 5 lakh international patent if it is filed, the individual entrepreneur can get reimbursement up to 5 lakh. For domestic patent, it is up to 1 lakh. GI registration, if it is done, because it is being another protection, intellectual property right, it is up to 2 lakh. Trademarks up to 10,000 rupees. In Goa, we have reimbursed till date some 7-8 cases trademarks. Then for design registration, up to 15,000. So these are some certain financial benefits MSMEs can get from Government of India. Now, what are the eligibility criteria? As was told by Mr. Sandesh ji that MSME registration, Udyam registration is very much essential. So registered MSMEs and who are having valid Udyam registration, they're eligible for applying for these schemes. Patent, trademarks, designs registered in the name of individuals are also eligible, subject holding Udyam registration in their name and having full ownership of the enterprise. This is very important. Proof of at least 15% shareholding in the enterprise in case of partnership form. Reimbursement not claimed by the applicant under any other scheme of central or state government. That should have declaration will also be required for this. Patent reimbursement applicable for. Now, which are the components for that? The facilitation fees, all government fees, design, diagram and drawing fees, attorney fees, consultancy charges, prior art search, analysis charges, patent application drafting charges, examination and publication fees. Associated with PCT, international foreign patent filing, is also a little bit covered in that. Which are the expenditures not included in this particular scheme? Cost incurred on renewal of applications, expenditure incurred towards assignment of IP, transfer of ownership, and cost incurred on correction in the application. These are not included. If you look at the trademark, reimbursement to 10K applicable, facilitation fees, all government fees, same like patent. Then for GI registration, reimbursement of similar facilitation fees, attorney fees, and maintenance fees. These are covered. Design registration, reimbursement up to 15K, which covers facilitation fees and all government fees, attorney fees, consultancy charges, application drafting, prosecution charges, examination fees. These are covered. Incubation, if you look at Government of India, definitely as per we are protecting IP through various attorneys, through various programs. We are encouraging MSMEs to go for this particular scheme. And this incubation component is very important because wherein we get from the students who are going to some colleges, engineering colleges, last year students, they are having good ideas with them and they can look for incubation. And we are having various centers which we call as host institutes available in almost all states. You can go on a board to get the list of host states. And this is basically the intention of this particular scheme is to support the untapped creativity of individuals and promote adoption of latest technologies in MSME that seeks the validation of their ideas at the proof of concept level. And this is very much important stride, or we can say a step for Atmanirbhar Bharat. Engagement with enablers who will advise such MSMEs in expanding the business by supporting them in design, strategy, and execution. Recognition of eligible institutions as host institute to act as business incubators. We call them as a business incubators because they incubate different ideas of either of students or from MSCs. And approval of ideas incubated is submitted through host institute. Assistance for nurturing of ideas to HI. So this is covered under the incubation component. This is we can say the process flow in general that host institute, then submission of ideas on portal, then first stage of screening, and the screening is done, then the ideas, then evaluation and selection of ideas by domain expert selection committee. DSC means that is constituted by any office coming under the Ministry of MSME, DC Office of DCMSME. They constitute this domain expert selection committee and they scrutinize these ideas and they are further forwarded to for PMAC for general other approvals or for selecting those ideas. So this is about the incubation component. The design component, another one which is also very important because in my MSMEs basically we find very core MSCs specifically who are in design, they can get benefit of that. And if they are designing some new design strategies or to design related products through interventions and consultancy from 21 IITs, NITs, IISc, IS, and this we also organize some design awareness programs to create general awareness and sensitization about the value and power of design for business through seminars, to talks, to workshops, to various national type of workshops we are organizing basically for encouraging this design. These are some process flow we can just say for design component. And here project assessment panel will be constituted and project monitoring advisory committee is there who had the final approval. Now till this time we are given 69 design projects were approved by our PMAC the central level. So this is what I have just to submit. Thank you very much.
Thank you, Kulkarniji. I think this was again very informative. So in the interest of time, let's quickly jump into the questions. The first set of questions is on the cost of PCT filing. So if any one of you could share insights on what's the cost, and that is specifically for entering Australia, cost of filing patent application in Australia through PCT. So
Yeah, I think during my presentation, I can take this. Sorry. So during my presentation, I spoke about the charges that is from India, USA, and Europe. I think Australia is more or less similar to Europe, around 50,000 or 55,000. This is only the official cost from the government side. And of course, the attorney cost will be separate while for preparing the patent application, for drafting the patent application.
Okay.
And sorry. Just to add, this is only the filing charges, and if you want to file the demand later on, there will be additional fee.
Okay, I guess there are multiple questions on PCT filing fees, so I guess that's answered. If not, then please type your specific question again. Moving on to the next one, is there any cap on number of filed patents for reimbursement? Also, if we acquire a filed or a granted patent, will that be reimbursed?
So actually, I'm not well versed with the schemes as such. I just know that there are some schemes, but my specialization is mostly around assisting for patent filing. Maybe Sir can answer. I think
Yeah,
he
yeah, they
spoke about
can be,
schemes.
they can be taken, reimbursement can be done for the patents, provided they are coming from micro, small entrepreneurs or as an individual, they can go for that.
So if I understand it right, Kulkarni ji, you're saying if the acquired patent also is from a small entity, then that can be reimbursed. Is that right?
Yes.
Thank you. There's another question on how can we use e-filing reductions by using XML file through PCT?
I think this
Basically,
question is
question
also, yeah, may I
XML.
speak? Am I
Yeah,
audible?
please. Yes,
Yeah, this
please.
is also related to some fees relaxation, as Sandesh ji has told. What I'm telling you, you just Google it, PCT fee tables. It includes all details you're asking, e-filing, what will be the fees, country-wide details, and everything is available there. There's also one more question like XML file, PCT application, and they are available there, details. They can go there.
Okay. Cool. Are deep tech startups eligible for reimbursement schemes for IP?
What is about SIPP scheme? What I can tell you, this is not about reimbursement scheme, as earlier told, but deep tech is recently 2 and 3 days before government notified this thing. I think this is, I think as far as I know, that is under SIPP scheme, they are equivalent to startups.
Okay.
And I think there is one SIP EIT scheme that is meant for electronics and IT startups or MSMEs. I think deep tech will also fall under that category. So they can look out for SIP hyphen EIT scheme.
Okay. Thank you. There is a question on 51% criteria. Can you please explain 51% criteria?
Is it for partnership firm or what?
I guess the question is not clear, but I think it was probably based on the details you would have shared.
Yeah, it is proof of at least 50% shareholding in the enterprise in case of partnership firms. But what happens? The individual who is registering the MSME, it should go with some Udyam registration, and Udyam registration requires uh, that Aadhaar number. So Aadhaar number of the one person who is having 15% share, if he is filing that, that will be considered.
Okay.
I hope I have answered.
Sure. Moving on to the next one, number of no cap on number of patent filings as of now for reimbursement. Okay, so that's a comment based on the previous question. We as an individual startup can directly apply for reimbursement, or is it through attorney?
No, generally attorneys won't support on that. I think they can themselves apply it, or maybe there are some consultants for those schemes also. Attorneys generally, they might be listed as facilitators, as I mentioned in the beginning, but they don't offer much support on the schemes as such.
All right. I think then there is a question on startups with limited budgets. What would you recommend as optimal timing and strategy for entering the national phase after PCT filing?
So I can take this, and maybe Jaivir sir can also add. Uh, so PCT filing is done at the end of 12 months. So that can be, once that is done, uh, depending on where you want to file. As I said, some countries have a limitation of 30 months, and some other countries have a limitation of 31 months. We can delay it as much as possible. At the 28th month, we will have the final IPRP. So post that, you can take a call. Once you get the patentability opinion from the International Searching Authority, post that one can take a call. After 28 months is recommended. 28 months from the date of filing of priority application.
Okay. I think we come back to the previous question in which saying yes, the answer given was for national phase, but need to know initial filing fees for EPCT. I guess that also can be looked up. Okay. What benefits do MSME get for maintenance fees?
That is also in 80% fees is concession throughout. It includes maintenance fees as well.
Okay. There's a question on any other limitation for PCT filing.
So the limitation, I mean, the main limitation is that PCT application is just a way, to get an opinion and facilitate to file the national phase applications, but it itself will not act as a granting authority. That's the major limitation of the PCT application.
Yeah.
Yeah.
Is claim amendment mandatory in PCT filing after search report?
No, I don't think so. It's optional.
Yeah.
Should we prioritize a few key markets initially, or is there value in maintaining wider geographic coverage through PCT system for as long as possible before making national phase entry decisions?
Should I?
Yeah.
Yes,
Sir,
Sandesh,
you
you
can take. Yeah.
please carry on. Yeah.
Okay. Okay. Yeah, I think we can wait till the market evolves, because once the PCT filing is done, all the 157 countries are open for national phase filing, right? So you can assess the market conditions. So the main parameters to consider as one is the market conditions, and I mean whether you have the commercial capability in that particular market. That is the first condition, and the other is competitor presence, and the third one is where do you have the manufacturing hub. Ask yourself about these three questions, right? And then you will have an answer for where you want to file it in, where you want to file the national phase filings. And as I said earlier, we can wait out till 28th month. Post the 28th month, we can decide about where to file.
Right. Thank you. How can we amend the specification if we have to add? So after amending the claim or specification Indian filing after FER response.
Yeah, the amendment is under section 57, 59 only. Two conditions should be generally met. First, whatever amendments you are making, that should be substantially disclosed in the specification before the amendment. And second is about claims. That amendment should fall wholly within the scope of the claim. But for PCT application, before entering national phase entry, that is different thing. You can amend according to PCT requirements.
Right. There's also a question on reducing reduction in fees in foreign jurisdictions based on criteria applicable in India. If you are a startup in an application in India and go ahead with PCT, then do we get similar concessions in other countries?
So each country have their own benefits for the startups and other things. I think in USA also the official fees is much lesser for startups and micro entities and medium and small entities. So I think each country will have their own facilities like what we have in India. That maybe once you decide upon where you want to enter, you will have to consult there a little more about it and then enter. But I'm sure something will be there like India.
Thank you. Does the applicant have to pay fees at national phase after filing international filing fees, search fees?
Yes, in
Yes,
India,
yes.
it is. In India, it is. In some countries like China, if you have availed their benefit of China or EP or US, they give some relaxation or relaxation fees. In India, its fees very, such fees is significantly low compared to these countries.
What is the most cost-effective approach for handling priority document filings? Dash, paper copies, or certified copies?
So, I mean, the one of the advantages with the PCT is that I may have missed out in my PPT is that once you record this, there is something called as IB 304, right? So that is the priority document filing. Once that is recorded with the PCT, if you are entering different countries through the PCT national phase application, the repeated filing of priority document can be avoided once the IB 304 is recorded. So I think maybe Sir can add on that.
Okay. There's follow-up comment on the amendment of specification. It says, can we make amendments in PCT filing before national phase filing?
Yes, you can amend under Article 19 and Article 34. Two opportunities are new, right? You can amend them.
All right. I guess we may probably take one last question. Other than the schemes, are there any strategies to reduce PCT filing fees?
Strategy can Sandesh handle. That is more their domain, I think.
Okay.
Sandesh, please, and can you answer this question? Because it's about strategies to reduce fees and all these things.
Yeah, so I mean, the strategy in the sense you can consider the parameters that I said. Basically, you have to carefully choose about where you want to file, how you want to file, and as I said, make sure that you file it early to avoid last minute fees. So all these things can be taken into consideration to avoid additional fees.
Okay. Okay, one last question before we wind up. Can SIPP facilitators also help with foreign filings?
Yes, from 2023 onwards, we have included these international applications also for the scheme under the PO scheme. If any user choosing the facilitator, they can file a PCT application, India choosing India as an ISA, so that filing fees is 15,000 rupees is they are eligible for reimbursement, not reimbursement, facilitator will be eligible that amount.
Right. With that, I guess we've come close to our session today. Really thank you. A big thank you to all the presenters for sharing a very practical insight into the how you can make a cost-effective IP strategy with respect to PCT filings. I'm sure looking at the questions, I think the information shared was found very useful. We also have some comments there. So thanks again, and hopefully, we'll continue to present more interesting topics going forward, and wish you all the best. Thank you again. Thank you to all the participants to join and for joining and also making it very interactive. Thanks.
Thank you everyone. Have a good evening.
Thank you, sir, for the insightful session.
Thank you, ASSOCHAM team, for coordinating this.
Thank you.
Thank you.